Thank you very much, and good morning, good afternoon, and good evening, everyone, depending on where you are joining us from today. And welcome to our rebooting of the WTO session entitled WTO Dispute Settlement. Where do we stand? I'm Dacio Castillo, Ambassador of Honduras, Chairman of the Dispute Settlement Body, and today the moderator of this outstanding panel that will offer us insight of our current state of affairs of the WTO dispute settlement mechanism and answer burning questions. I understand that we might be close to 3,000 participants linked virtually, and I would like to thank the organizers for setting up such a fantastic meeting that brings us together to talk about WTO dispute settlement. We don't have much time, so let me explain how we will proceed. All these speakers are worthily known, and I will not introduce them at the beginning. We will have a first round of presentation in which each speaker will have about 4 minutes to talk about the questions raised in the invitation which concerns the risk currently faced by the WTO dispute settlement system, the multilateral trading system, and the concept of international rule of law. The alternative of potential solutions within and outside the WTO system, and the options for further unilateral, bilateral, regional, or plurilateral remedies and countermeasures, and whether the WTO trading system can function without multilateral enforcement. Afterwards, we will have a second round, which each speaker will have 2-3 minutes to comment on each other's speaker's presentation or make additional statements. Finally, we will open the floor to questions from the audience. For logistical reasons, we will be able to take questions only when sent to all panelists in the Q&A chat box. You can send them from the beginning. So thank you for that. So let's start. First, Ambassador Stephen de Boer, who is with me today at the WTO building. Ambassador de Boer is the permanent representative of Canada to the WTO. Canada has played an important role in supporting the WTO dispute settlement system, including with its successful and creative mechanism entitled Mechanism for Developing, Documenting, and Sharing Practices and Procedures in the Conduct of the WTO Disputes. We all know Canada's effort to resolve the Appellate Body crisis. Thank you, Stephen, for being with us today. Stephen, do you think that we can reach one or more workable solution to the current WTO dispute settlement crisis?
Is that my introduction?
There you go.
Well, thank you very much, Ambassador Castillo, and it's my pleasure to speak to this panel today. So, rather than answering your question directly, let me talk about 3 elements that I would like to address. The first is the key role played by the WTO dispute settlement system. The second, the importance of a functioning appellate body within that system. And thirdly, I want to touch briefly on the function of the MPIA in the current context. And I think that will go a long way to answering Ambassador Castillo's questions. In 1995, WTO members agreed on a set of rules to discipline international trade. They wanted to develop an integrated, more viable, durable multilateral trading system. And these agreements are binding on the members. In the world of international trade, disagreements occur, and there is a need for a neutral arbiter to settle them. It was a fantastic achievement for the members to agree on a dispute settlement mechanism under which decisions are binding unless all members reject the decision. Such a system, and the right to adopt countermeasures when a member does not comply with decisions, contributes to confidence that members have that their fellow members will respect their obligations. Canada has always been and will be a very strong supporter of the rule of law. Impartial third-party adjudication is an essential tool to buttress security and predictability in our multilateral trading relations. Given the complexity of international trade rules and the disputes that may arise, it is not surprising that panels tasked with deciding a dispute may err in doing so. And the appellate body has a fundamental role to play in correcting erroneous panel decisions and ensuring that there's coherence in the interpretation of the agreements. The current situation entails significant risks. The lack of a functioning appellate body means, first, that by appealing into the void, a respondent can frustrate a complainant's right to a binding decision. Second, without a functioning appellate body, there is significantly higher risks that erroneous decisions will be made and that fragmentation in decisions will arise, resulting in uncertainty as to the meaning of WTO rules. And this endangers stability in international trade. The fact that members have agreed to a dispute settlement system does not mean that they will always agree with the decisions made under it. In adjudication, domestically as well as internationally, very often one party is pleased with the outcome while the other is not. Yet disagreements with certain decisions is not a sufficient reason to reject the existence of a dispute settlement system. If it were, there would be no such systems. Now, saying that the system is very important does not imply that it's perfect. There are issues, for example, with respect to the length of time it takes for decisions to be made and for disputes to be resolved. Justice delayed is justice denied. Therefore, it is important to address delays in adjudication. This should not, however, be done at the expense of quality. In relation specifically to the appellate body, concerns have been raised regarding the fact that the AB has missed the 90-day time frame to issue reports. This is a serious concern that needs to be tackled, but it's also important to put it into perspective. A quick review of WTO disputes shows that the degree of complexity and the number of claims and arguments presented to WTO adjudicators has grown considerably over the history of WTO dispute settlement. Governments and stakeholders, as well as WTO adjudicators, should therefore remember their shared responsibility in focusing proceedings on the elements that are cardinal to resolve their issues. While efforts are made to speed up the appellate stage, we must also remember that our stakeholders care about the period of time that's taken to resolve the whole dispute. If we're serious about timelines and timeliness of dispute settlement, the overall proceedings have to be part of the discussion. Canada will continue to work with all WTO members on creative tools to foster speedy resolution of trade disputes at the WTO. Canada's priority is, and it is for a very large segment of the members, to find a multilateral solution to the AB impasse and one that includes the United States. Until such a day where circumstances enable solid and serious discussions towards resolving that issue, Canada and now 23 other WTO members have endorsed as an interim measure the Multi-Party Interim Appeal Arbitration Arrangement, or MPIA, which safeguards our DSU rights to binding and two-stage adjudication. I will stop there, Ambassador. Thank you.
Thank you very much, Stephen, for your speech. Our next speaker is Ambassador Joao Aguilar Machado. He's the permanent representative of the European Union to the WTO. The EU has been a very active actor in the WTO work to review and improve the WTO dispute settlement system since the beginning of the WTO, when Joao was a young consular here in Geneva. The EU works restlessly in the Appellate Body turmoil and, together with other like-minded WTO members, is recently initiated a process for a plurilateral interim arbitration mechanism that everybody knows, like the MPIA. Looking forward for your comments, Joao.
Thank you, Matthew. And I would like to start by thanking you for the kind introduction and also to the organizers for facilitating this exchange of views. Given the current appellate body situation, now it's indeed a good time for all of us to sit down and see where we stand. On one thing at least, I think we all agree. The WTO dispute settlement is not in a good place right now. The impasse over the appointments to the appellate body means that that body is in effect paralyzed. This affects not only the right of WTO members to bring appeals, it also affects their right to a binding positive solution to disputes. Not all WTO members will agree on how exactly we got to this bad place, and they don't need to. But if the WTO is to remain a linchpin of the global trading system, members will have to agree, better sooner than later, on where we go from here. Finding such an agreement is a major priority for the European Union. Along with others, the EU has made specific proposals to address various concerns and has actively supported the efforts to find a solution as they were encapsulated in the draft General Council decision put forward by Ambassador Walker in December 2019, which in our view were a good basis for moving forward. However, this has not been enough so far to resolve the impasse over the appellate body appointment. So the question remains, where do we go from here? The European Union is open to meaningful reform, but such a reform should move us forward, not backwards, to a time that predates the WTO itself. It is crucial that the effectiveness and legitimacy of the WTO dispute settlement system be strengthened, not undermined. Such dispute settlement is needed to ensure that agreed rules, including new ones, are adhered to. It is a necessary condition for the security and predictability of a multilateral trading system. Without a robust dispute settlement mechanism, we risk slipping into power-based relationships and denying our businesses a secure and predictable environment in which they can thrive. For the EU, this means that any reform would need to preserve the core features that are in the DSU. And this includes a dispute settlement that is binding, two-tier, and independent and impartial. I want to make clear that in the WTO, panels and appellate body are not courts. And this is recognized through the various features of the DSU, including the existence and functions that are delivered by the dispute settlement body. And we think that this role of the WTO membership, it is the role of the WTO membership in the dispute settlement process, including their oversight over the work of adjudicators, must be preserved. It is also clear that it should be for the membership and not for adjudicators to set new rules. That is why strengthening the negotiating function of the WTO is an essential pillar of its reform. Now, I would like also to say a few words about the MPIA and to make clear that the interest and decision by a number of members of the WTO, now amounting to 24, to establish the MPIA, the main motivation is exactly to preserve the core features of the dispute settlement system. And that is the reason why the EU and a growing number of members, now totaling 24, have put in place the MPIA. The MPIA is open to the participation of the whole WTO membership, but it is a temporary initiative designed to be in place only as long as no lasting solution to the appellate body situation has been found. The MPIA is not in itself a vehicle for WTO reform. And I think it's important. It is not an attempt at reform. It's only an attempt to preserve the two-tier system that is very much cherished by a number of the members. However, the MPIA does include a number of innovations to enhance the procedural efficiency of appeal procedure. And I think that we have by now created a pool of arbitrators of the highest quality, outstanding individuals, which augurs very well for the quality of future rulings. I would like to stop here, Ambassador Castillo, and come later in the debate. Thank you.
Thank you very much, Joao. Now, join us virtually from Washington, D.C. I would like to welcome Ambassador Denis Che, Permanent Representative of the United States of America to the WTO. While the United States was the first promoter of the GATT, championed the WTO and its dispute settlement system on which it's remained. The top user, the US has expressed dissatisfaction with the WTO, and in particular with its dispute settlement system. We are pleased today to have you with us to continue to work on improving the DS system. So, Denis?
Let's see. Okay. Can you hear me, Dacio? Can you hear me, Dacio? Can you hear me, Dacio?
Mr. Ambassador, we can all hear you from our side. You may go ahead.
Very good. Well, good morning, Dacio, and good morning, colleagues. It's great to see you. And I want to thank Gabrielle and the Graduate Institute for hosting this session today. You know, I was intrigued by the title of today's panel, WTO Dispute Settlement, Where We Now Stand. I think there's little doubt about where the United States currently stands on WTO dispute settlement. In fact, no other WTO member has more comprehensively detailed its concerns about the current system. Over the past 3 years, in numerous interventions at the WTO, and I can say some of them were quite long, we have explained how the appellate body had repeatedly failed to comply with WTO rules, both substantive and procedural, and had interpreted the WTO agreements in ways not agreed to by members. This past February, the Office of the United States Trade Representative published a 174-page report putting all this information together in one place. And this is it. The hardbound copy, I don't think it's available in Geneva, but it is here in Washington. But you can find the report to the listeners on the USTR website, and I encourage everyone to take a look. Last year, the United States was also actively engaged in the Walker process. During this process, we provide specific comments on some of the language contained in the guidelines drafted by Ambassador Walker. Unfortunately, very little of what we offered was taken on board. We also raised some fundamental questions. In many respects, the proposed guidelines simply repeated what was in the DSU. So we asked the membership, why would the appellate body respect these new words when it has not respected the old words in the DSU? It seemed to us that simply reaffirming the rules that the appellate body had repeatedly broken was not an effective solution. More fundamentally, we sought members' views on why the appellate body felt free to disregard the clear text of the DSU and why the membership itself allowed the rule breaking to continue for so long. This is the famous why question. Unfortunately, the membership failed to engage seriously on these issues. So as we assess the current situation and potentially chart a course for the future, it's important to step back and look at the bigger picture. In the US view, the appellate body was not designed as an international court, nor were its members to be considered as judges. As expressed in the DSU, the WTO membership never charged the appellate body with creating a body of international trade jurisprudence. Its role was simply to make recommendations that would assist the DSB in resolving individual disputes. The role of issuing authoritative interpretations of the WTO agreements has always been reserved to the members themselves, acting in the ministerial conference or the general council. The job of the appellate body, therefore, was always meant to be a limited one, to correct egregious legal errors by panels. And for each panel, the appellate body was supposed to complete its work as a general matter within 60 days, and no later than 90 days. To underscore the intended limited role of the appellate body, its members worked part-time and were not required nor encouraged to live in Geneva. The debate over the past 2 years demonstrates that some WTO members have a fundamentally different vision for appellate review than the limited role that is set out in the DSU. It's clear some members saw and continue to see the appellate body as an independent international court and its members as judges who inherently have more authority to make rules and create jurisprudence than the focused review provided in the current rules. These same members envisioned the appellate body as the centerpiece of the dispute settlement system, not just one component of that system. Now, we've heard about the arrangement, the alternative appeal arrangement recently created by the EU, China, Canada, and others. In our view, the arrangement incorporates and excuses some of the worst aspects of the appellate body's rulemaking. It allows for appellate fact-finding and weakens the mandatory 90-day deadline for appellate reports. Perhaps most significantly, the arrangement promotes the use of precedent by identifying, quote, consistency and coherence of decision-making, unquote, a phrase that appears nowhere in the DSU as a guiding principle. The idea here, it seems, is to continue the appellate body's misguided quest of trying to build a global common law of trade that is built on its unique interpretations of the WTO agreements. It also suggests permanently baking in appellate decisions, even if they are wrongly decided. These fundamental differences or clash of visions about the appellate arm of the dispute settlement system can't be papered over with a few word tweaks here or there. Now, in a recent Wall Street Journal op-ed, my boss, Ambassador Bob Lighthizer, argued that the WTO dispute settlement should be totally rethought. He described a single-stage dispute process akin to commercial arbitration. Ad hoc tribunals would be impaneled to quickly resolve a dispute. The rulings of these one-off panels should apply only to the parties in the dispute and not become part of an ever-evolving body of trade jurisprudence. Ambassador Lighthizer also referred to a mechanism that would allow WTO members to set aside erroneous panel opinions in exceptional cases. So I would be interested to hear thoughts from my colleagues on this perspective. Now, in the meantime, I'll finish up soon, Dacio here, but in the meantime, it's important to recognize that global trade continues. The dispute settlement system also continues to function, and members are continuing to turn to the WTO. Over the last several months, we have seen the DSB consider panel requests at the last 5 DSB meetings. In all, 8 panel requests have been considered by the DSB. Where panels have been established, members are considering what makes sense for their dispute. In some disputes, members agree at the start of the proceeding not to appeal. That happened in Indonesia safeguard on iron or steel products, in which Chinese Taipei, Indonesia, and Vietnam reached procedural understandings that included an agreement not to appeal any compliance panel report. In U.S., anti-dumping measures on certain oil country tubular goods from Korea and the United States also agreed not to appeal the report of any compliance panel. Just regardless of the path chosen, the central objective of the dispute settlement remains unchanged: to assist the parties to find a solution to their dispute. As before, members have many methods to resolve a dispute, including through bilateral engagement, alternative dispute procedures, and third-party adjudication. So thank you very much, Dacia, for this opportunity.
Yeah, now yes.
Thank you, Dennis. We are having some kind of IT problems, but we are moving forward. Allow me now to welcome Mr. Angel Villalobos, Ambassador and Permanent Representative of Mexico to the WTO. As you all know, Mexico has been on the forefront of the proposals for the activation of the selection of a new members of the Appellate Body, a proposal that has close to 121 signatories. Mexico is a big user of the WTO dispute settlement system. Angel, thank you for joining us. And are you optimistic with the future of the WTO DS system?
Thank you, Dacio, and thank you to Gabrielle for all her work to organize this event and for convening this interesting discussion during the trade week. I appreciate the opportunity of sharing this panel with my dear colleagues. If I had any optimism, I just lost it after what I heard from my previous speaker. Let me start by saying that the appellate body, the AB, has certainly become a zombie, a dismembered zombie. How we got here to have a diminished system to solve dispute is a long story which requires future forensic work. On the AB demise, I wonder if it is a case in which the baby was thrown out with the bathwater when possibly some focused solutions were at hand. But well, what is done is done. I must confess that I always had a strong belief, almost a faith, that a zombie will be saved from becoming a zombie, that eventually we will engage in a constructive discussion to restore the AB, especially after the intensive engagement of the membership during the Walker process. We must remember that there were 12 proposals submitted for more than 90 members, either jointly or individually, trying to address the concerns raised by the United States. Ambassador Walker identified convergences among members in order to unblock the appellate body, produced the so-called Walker principle, and sought to approve a draft decision during the December GC without success. As just was mentioned by Ambassador Shah, the US noted that the decision did not address their concern and that it was foremost important to understand why. The appellate body had not complied with the rules. Shortly after that came the MPI, and I will advise not to prejudge the performance of the MPI. We may have some time to do that. And after that, even after the USA lengthy report on the appellate body, the mood was having to work on a restoration path. But the recent op-ed by the USA representative, as was explained by Ambassador Shah, with a single arbitration and with some other elements away from the current system, given such view, the restoration track for the appellate body seems to be facing a bigger challenge than before. Let us remind that the appellate body is or was considered the crown jewel of the dispute settlement system, and Gabrielle, in her kind invitation to this panel, referred that the WTO appellate body was seen as a miracle in the international arena. Who knows, as things develop and out of the forensic work, it may result that the jewel in the crown was a custom jewelry and the miracle was a mirage. Hopefully not, but if there is no intention from all members, we might be at the beginning of the end of the exceptionalism of the WTO dispute settlement system in international law. And coming back to your question, Dacio, no, I'm not optimistic, and it will take a lot of effort from all members to restore a really functioning dispute settlement mechanism. Thank you very much.
Thank you, Angel. Next, I would like to welcome Ambassador Shan Chang, Permanent Representative of the Republic of China to the WTO. Ever since its accession, China has been very active and engaged user of the WTO dispute settlement system. It has also submitted proposal on systemic substantive, and procedural issues of the dispute settlement system, and has repeatedly underlined the benefits of the WTO and its dispute system. Thank you for being with us, Chen Chen. Where do you think does the WTO DS stand?
Thank you, Dacio. Good afternoon, dear colleagues. Good morning, Dennis. Let me start by directly answering the question of today's event, i.e. Appellate Body and the dispute settlement system is standing on a shipwreck, and we have to do what we can to save it. It's obvious that everyone realizes the imperfection of the AB, but the understanding and the degree of its severity differs. I'm not so optimistic that we could reach a consensus on the severity issue, which is quite subjective in nature. But I believe that in any event, this doesn't prevent us from jointly exploring the way to improve the system. Several concerns on the AB have been raised during the previous discussions, among which some might be easily addressed, like the 90-day deadline. In my view, attribution of all faults of violation to the Appellate Body is unfair, and simply force the Appellate Body members to strictly comply with the deadline is not the way out. We also have to examine ourselves. Since 1996, 66% of all panel reports were appealed, which has already constituted very heavy workload for the AB members. If the disputing parties bring claims as many as they can without showing any self-restraint, the faithful implementation of a 90-day deadline becomes a mission impossible. All the AB members will have to have no option but to make a perfunctory effort if they are forced to comply with their obligations. That is neither the outcome we expect, nor the objective of having AB. In a nutshell, the disputing parties need to make efforts and adhere to certain abstinence in the dispute settlement process. Comparing to the 90-day deadline, some concerns are more complicated. Hence, the difficulty to address them is higher. Overreach is one of them. And we also have unpleasant appearance in this regard. Taking China's export restriction case as an example, the AB members ruled that China has no right to resort to the general exception clause, which we couldn't endorse, but nevertheless still compelled with this ruling. The improper assessment and reasoning by the AB members in this case obviously doesn't reflect the negotiated outcomes. As negotiators, I think everyone here knows the meaning of constructive ambiguity. When a dispute arises, each member will bring its own understanding of a given provision before the panel and AB. When such lacunae are brought in appeals, the Appellate Body is placed in a dilemma. Any of its clarifications or explanation of disputed contents will probably be viewed by one party as filling the gap. If the Appellate Body chooses to apply the principle of non-liquid and refuse to rule on the issue, it could also be criticized as underreach. It's true that keeping a fine balance is easy said than done, but the limited choice we have either urge the AB members to faithfully fulfill their mandate given by the DSU and require them to strictly apply the customary rules of interpretation of public international law, or renegotiate the obligation contained in the WTO agreements among ourselves to give them more precise guidance. Meanwhile, as a Chinese saying goes, going beyond the limit is as bad as falling short. We have to avoid going extreme in the opposite direction, i.e. underreach, in the process of solving the overreach problem. Before concluding, I would like to emphasize one important point. No matter how serious the problem of AB is, the AB had played invaluable role in solving many disputes, and we could not, as our colleague Andrew just said, throw the baby out with the bathwater. The idea of going back to the one-tier system is problematic, which means the teeth of the WTO will be extracted. The WTO without teeth will not only fail to effectively solve the disputes among its members, but will seriously jeopardize the negotiation function due to the failure in guaranteeing implementation of agreements. It is not the members' interest to have an organization lacking of authority and effectiveness. Thank you, that's all.
Thank you very much, Sheng. Our sixth speaker today, joining us from Brussels, is Ms. Claudia Orozco. Ms. Orozco's achievements speak for themselves. Claudia was a delegate from Colombia in the beginning of the WTO, and she worked on the establishment of the ACWL. She works now as a trade expert, and she is the most frequently appointed WTO panelist. Recently, Claudia was selected as one of the 10 arbitrators under the MPIA. Claudia, how do you see the future of the WTO dispute settlement system?
Thank you, Dacio. Thank you, Ambassador, for your remarks, and thank you for all the organizers, and thank you for the remarks by the previous speakers. The subject of this session is quite important and quite clear. Where do we stand? The world stands in a very delicate crisis. Therefore, I would like to address some of the risks of this crisis, and I would like to start with a consideration that the current crisis is not a crisis of the appellate body. The current crisis is a crisis of the entire dispute settlement mechanism, and therefore it's a crisis that touches on the rule of law of the WTO. The rule of law of the WTO is very well spelled in the same agreements of the WTO. First, you have Article 2 of the Marrakesh Agreement that incorporated the principle of the single undertaking, and that indicated that the multilateral trade agreements in Annexes 1, 2, and 3 were binding on all WTO members. In parallel, under the dispute settlement understanding, Article 23 indicated that any determination of a breach would be done through a third-party adjudication process, which is the two-tier panel appellate body mechanism. So what is in crisis is the whole system, because proceedings that have gone through consultations and then to final proceedings cannot come to an end. And this is what we're talking about. The risk of not solving this situation is the erosion of the faith in the dispute settlement mechanism. That is already happening, because while panels are being composed and panels are being established, these were the cases that were in the pipeline. When one looks at the new consultations, one sees a symptom. Consultations in the WTO have ranged between 50 and 8 in a year. This year, 2020, there have been only 3, and there seems to be none in the pipeline, which shows that the dispute settlement mechanism is starting to erode, and there is no interest in using it. The second consequence of this situation continuing in time will be that there will be an erosion on the monitoring functioning of the WTO. The work of committees is fed by notifications, by exchanges of information, and they are fed and they are interesting because if they cannot be resolved and the situation is meaningful for private undertakings, they can go to dispute settlement. The last and third risk is that the rulemaking of the WTO also becomes eroded because there may be no interest in agreeing to new rules. These new rules are necessary. It's clear there is a list of subjects that have been identified as important for new rules, and there will be little interest in coming up with new rules if there is no enforcement. So ultimately, this crisis will affect the credibility of the WTO and the relevancy of the WTO. And therefore, the second question is quite important. Are there solutions that could be created alternative to the dispute settlement of the WTO? And the clear answer is no. It will be necessary for the members to look into possibilities and to look into the experience of the past 25 years. The past 25 years will show that dispute settlement has been frequently used. It shows that the appeal process has been frequently used because it has been over 60% of panel reports have been appealed. But importantly, it has shown that panels do not frequently commit manifest errors, which was the reason to create the appellate body. And therefore, the appellate body has a place in the system, and that place needs to be narrowed down to what is necessary. And therefore, there are important questions that need to be addressed by the members, in particular, how to narrow down the scope and the work of the appellate body so that it addresses only matters that are appealed and that are meaningful to the solution of the case at hand. Second, how can you enforce the mandate of awards in 90 days? This is important because it narrows down the work of the appellate body to that which is essential. It also eliminates the interest in litigation simply because it is a way to postpone implementation. Thirdly, it may be important to ask the question as to what kind of additional experience would be desirable in members of the appellate body. It may be important that members in a future entity have experience with dispute settlement in the WTO. It also could be important that they have practical experience in the implementation of the agreements. This, in trade remedies, was a black hole in the appellate body. Finally, it will be important to establish whether there are situations that may merit that not only 3 members of a division look at the appeal, but maybe the entire appellate body. If it is a first-time interpretation, or if it is the interpretation of a core legal concept, it may warrant that all 7 participate in the decision, not just 3 of a division. It also is important to clarify what is the role of the Secretariat and what is the organization that is more advisable for that future appellate body. Ultimately, it's very important to resolve these questions because the rule of law of the WTO is essential to the rest of the world, not to the members, but to the private undertakings. Private undertakings have been for 25 years making investments, sometimes to become export-oriented, sometimes to comply with SPS measures in a jurisdiction of interest, other times to develop a particular value chain and process of productions that reflect those market access arrangements that were adopted with the Uruguay round. And this is no time to say, well, all that you have done is now in the air because there are no rules that are enforceable. The private undertakings that do the investments, they need certainty, and therefore the mandatory dispute settlement mechanism is essential for the relevance of the WTO. Thank you, Ambassador.
Thank you very much, Claudia. It's always a great pleasure to see you. Finally, allow me to welcome Mr. Jorge Miranda of Cassidy Levy Kent, LLP, also join us from Washington, D.C. Mr. Miranda is a trade remedy expert and worked with the WTO Rules Division for several years, before turning to a private trade remedy practice in Washington. Jorge has written critical articles of some of the interpretations and actions of the appellate body. Jorge, I would like to hear your comments.
Thank you, Ambassador. I'm delighted to be here, and I'd like to thank the organizers, especially Gabrielle Marceau. This is an important event. My approach would be sort of middle of the road, and let me explain why I think that is the case. Unfortunately, not all was well with the AB, and I will explain why. I think essentially what happened is that while the AB made some outstanding achievements as a rule, unfortunately, over the last few years, it made a series of errors in cases mostly concerning trade remedies where it incurred in manifest errors. You see, these were errors under any standard objectively, and I will explain that in a moment. And unfortunately, those errors were coupled with the modality of case law the AB adopted. Meaning, if you look at how case law is handled in different jurisdictions, the case law is never as strong as what the AB adopted, right? So you have a combination of a number of egregious decisions, egregiously wrong decisions, combined with the inability to backtrack because of the hardline modality of case law that was adopted by the AB. Now, let me be very clear. I'm not saying that the AB normally or generally or made mistakes. I'm not saying that a large proportion of the decisions are erroneous. I'm just saying that over the last few years, these mistakes did happen. And I think we're going to go nowhere if we keep up pretending that no decisions were manifestly flawed. By the way, I've written a paper, as you know, on this issue, which is publicly available. I wrote it with a colleague, Manuel Sanchez-Miranda, from the Institute. And it explains in detail what I'm going to try to summarize in the short time that we have. But let me focus on two case studies. The first one has to do with a decision in the fasteners case, where the AB addressed an issue that was not part of the terms of reference. Now, this is really interesting because most people would say, well, this was obiter dicta. Perhaps not, because obiter dicta is normally a finding that you may get into in the process of getting to your main finding. So it's sort of an auxiliary finding, if you will. But in fasteners, the AB made a finding that had absolutely nothing to do where it was going. Now, why did it make that finding? I don't know. I'm at a loss. You tell me. But the fact of the matter is that this was a finding, again, not in the terms of reference, totally unnecessary, and nevertheless, the AB chose to go into that without having the benefit of representation by parties as to, who was right and who was wrong in respect of the issue concerned. This is very grave. If we don't understand that this was a problem, then I guess, getting into the other issues is going to be even more difficult. My second example, and again, all these examples are in the paper. My second example has to do with the interpretation of public body. As we know, in subsidy cases, the subsidies may come from the government through a financial contribution, or may come from a public body. Traditionally, this term has been interpreted as an entity owned and controlled by the government. And of course, there was a huge controversy as to whether that was necessary. The point is, well, maybe ownership and control is not sufficient, because you could have circumstances where there's control so that the entity at the end of the day looks after the interests of the state as an investor, not in terms of implementing public policy. So perhaps this test was insufficient, but then in that case, the AB made findings that essentially require public bodies to be endowed with authority. Now, this is, in this context, a real problem, because you're talking about public bodies providing goods and services, meaning these public bodies are entities that actually engage in commercial behavior. And yet the AB made a finding that these entities couldn't be seen as public bodies unless they had authority. But again, that's a problem, given that these entities are, of course, in commercial business. They're not regulators, and they couldn't possibly have authority. So again, these are two findings that I find deeply problematic. Now, nothing much would have come of that if the modality of case law adopted by the AB had been more flexible. Just to give you a few examples, in most jurisdictions, case law works very differently from what the AB adopted. The Mission of Honduras has put out a paper that is really interesting in this regard, and it illustrates how in Latin America, for example, you only get to have jurisprudence after a number of consecutive findings by a tribunal. But this is not what the AB adopted. That was one modality. Now, in the US, you also have case law, of course, but this is a case law that is much more malleable in the sense that, for instance, a court of appeals can revert its findings, and it can also give due weight to dissenting opinions, and this did not happen either. In the modality of case law adopted by the AB, unfortunately, everything is cast in stone at the first shot, and its own errors are not legal grounds for backtracking. And also, it's unclear what weight, if any, should be given to dissenting opinions. So again, you have, unfortunately, most unfortunately, a combination of egregious mistakes, again, not generally, but some that did happen, with the adoption of a version of case law that is really hard. So I think the only way to get out of the morass would be for a consensus to be built about the fact that, yes, in fact, these mistakes happen, that, yes, in fact, this modality of case law is too hard, and then perhaps granting the AB the explicit power to create case law, subject to the proviso that this modality of case law should be much more flexible. We all know that tribunals are going to be making mistakes. What we don't want to continue having is our decisions that are wrong, objectively wrong, and that cannot be, at the end of the day, overturned. I think that's a serious problem. And again, don't get me wrong. I'm not saying that the whole AB was a failure. Of course, not in his right mind would think that. But unfortunately, we do have a problem, and unless we accept that there is this problem, then I'm not sure that we're going to get anywhere. That would be a most unfortunate scenario. Thank you so much.
Thank you very much, Jorge, and thank you very much for your comments. We have heard a lot of good information this afternoon, and now I will ask each speaker for their comments. Of course, the time is our enemy, so I will kindly ask to keep yourself to 2 to 3 minutes maximum. For the second round, I suggest that I will start with Joao, then Angel, followed by Jorge, Stephen, Shanshan, Claudia, and last one, Dennis. So I will give the floor to Joao to make the comments on comments.
Thank you, Dacio, and it was good to hear the different views and the interest that there is to try to reform dispute settlement in a way that we can get back to a system that is operational and effective in enforcing members' rights and obligations. As I said in my earlier intervention, the EU does not regard the appellate body as a court. Even our Court of Justice has said that. They nevertheless operate adjudicative functions. And I think there is no denying, and it is in the interest of the membership that these are impartial, of the highest quality, because their rulings are binding, and it's very important for WTO member governments to have high quality, impartial rulings, which have consequences later on. Notably, governments have to go back to parliament and ask for changing of the laws. And that's the reason that for us it is very important to have a two-stage. It's important because we need to have high quality rulings and that there is an appeals level that can review legal errors and correct. And this is extremely important for the legitimacy of the system. And that's why we always felt that we should remain with a two-stage dispute settlement. But of course, we are open to discuss how best can we get it back and to address the concerns that different members have after having seen the appellate body operating for 25 years. Now, I think it's a bit unfair to claim that the MPIA incorporates the worst errors of the appellate body and promotes the creation of precedents which are not in the DSU, and it's for the very simple reason. There is not yet a single arbitration award that has been issued in a case covered by the MPIA. So I think it's really premature and unfounded to be claiming that. Secondly, as I indicated in my first intervention, the intention and goal of the MPIA is not an attempt to reform. It's an interim solution that we hope can be as short as possible until we have, again, a working appeal system in place. But what the participating members wanted was to have an appeal system that operates, and the only system that we have worked for 25 years is the appellate body system. And we were not to start negotiating new ways of conducting arbitrations, again for a simple reason, because the MPIA is not a vehicle for reform. Yet, we have introduced a number of efficiency and ways to improve the efficiency, the procedural efficiency, notably to try to get the reports in 90 days. So there was, the member countries were mindful of the need to try to make sure that we can have reports that are issued in 90 days, but it was not intended to be an attempt to reform the appellate body or the dispute settlement system. This has to be done with the whole participation of the WTO membership. Cannot be done only by a group of countries, and that's why that we look forward to have all members engaged so that we can address the concerns that have been raised, not losing sight that at the end of the day, it's in the interest of the membership, or at least that's clearly our conviction for the EU, that we have an appeal system that is efficient, that helps to solve the disputes, that brings a solution and a positive settlement to the dispute, yet that it is impartial, of the highest quality and binding. That for us is the bottom line. Thank you, Dacio.
Thank you, Joao. Now I turn to Angel.
Can you hear me now?
Yes.
Yes. Okay. Well, I'll be brief, since I guess this panel will never be accused of having a few panelists panel. So I will make quickly some comments, and I'm going to concentrate in some of the questions. One of the main risks that I see is that, and like was mentioned by Ambassador Garcia, things are not normal. The possibility of after the panel not being able to someone to appellate, that's a very important part of the system, and that's blocked. So what I'm seeing here now is kind of a fragmentation. So we will have the MPI, which is about to kick in, and then we'll have the normal way that finally has a dead end somehow. So my concern is that this fragmentation might last for a long time. And if this lasts for a long time and is not perceived as something temporary, it's going to weaken the appetite to negotiate. And in the other hand, it's going to affect the business plan of corporations. So somehow it's going to impact investment, exports and imports. So it might have a really important effect on the engine of growth associated to trade. And I should also recognize that some of that resilience, the relevant work of the well-known committees like SPA's activity, that allows members to have discussion and could contribute to preventing disputes. Maybe see an emphasis on work harder on these committees, and also work harder on the consultation part of the dispute settlement system, which I must underline that 51% of the consultations get solved at that stage. And at the end, only 20% of what started as a consultations end up with a report by the appellate body. And concerning that, is any value in exploring other international dispute settlement system, particularly under the bilateral or regional agreements? I guess it's worth it, but we must mention that there are some issues. Most of them do not have the way to solve anti-dumpings and so on. It has not trade remedies. Many of them don't have strong secretariats, and they lack some practice in dispute settlement. So it's an option. In the case of Mexico, now with the USMCA, provides a platform to dispute settlement. And let me underline that 77% of exports go to the United States. So for us, it's important to have that option. And we also have in the CPTPP and with our agreement with the European Union, but in those cases we do not have the remedy. So it's an option, but it's limited. And in the question, they ask if it was an option to go to unilateral or regional countermeasure and remedies. Of course not. If you are a mid-sized or small country, such a power-based scheme, always we end up with a short end of the stick. And concerning if no solution to the dispute settlement mechanism challenges is found, can the WTO trade system function without multilateral conforming? The long answer is no. Thank you very much.
Thank you, Angel. Shen.
Thank you, Dacio. I fully concur with the assessment of many colleagues that the paralysis of the AB pose greatest challenge to the multilateral trading system. Nevertheless, other international dispute settlement systems, such as bilateral, regional, or multilateral mechanisms, including MPIA, could only be viewed as potential dead tolls, but they have no way to replace the WTO Appellate Body. There is no doubt that the Appellate Body is subject to reform, but any reform should preserve the dispute settlement system's compulsory, impartial, rule-based, enforceable nature, of which the appellate review is an integral element. We realize the complaints by some members about the AB rulings, and at the beginning, as I said, the same applies to China. However, we should distinguish between the institutional issues and the problems caused by individual accidental reasons, and the reform should focus on the former, the institutional issues. This is not to say other causes, such as the personal factors, can be ignored, and to ensure their adherence to agreed rules, various means can be adopted to enhance the accountability of Appellate Body. This may include making guidance for appellate review, establishing an oversight committee, strengthening the peer review, and press monitoring. So I am confident that the members have the capability and the creativity to make our system more effective and operational. Thank you, Dacio.
Thank you, Shen. Jorge?
Yeah, thank you. I just want to be extra brief with respect to whether you could have the regional agreements serve as an alternative. Based upon what I've seen in the case of the NAFTA, I would think not. Frankly, a lot of people refer to the AB as the crown jewel of the WTO. I disagree. I think the crown jewel is actually the Secretariat, and all these regional agreements don't have anything in the nature of the WTO Secretariat. So the reports you get are very inconsistent. Some of them are very good. Some of them are extremely poor. So WTO dispute settlement is the best there is in the world. Now, second, at least in my opinion. Now, secondly, I'm an optimist. I think at the end of the day, we have to recognize that, you see, there's no reason why all of the texts are going to be perfect the first time around, particularly when it comes to the dispute settlement understanding. So it's just human that at the end of the day, most of the system works fine. But when it comes to dispute settlement, we do have some issues, and I don't think we have a problem recognizing that. I mean, it's not that much of a big deal, provided we understand that the AV couldn't have been infallible, right? Which is, I think, the doctrine underpinning the problems. Now, Ambassador Zhang just mentioned the possibility of oversight, and I think that's a great idea. I mean, you could have not only the members grant explicitly the AV the power to create case law, subject to for instance, the Latin American modality or the U.S. modality of backtracking with due attention paid to dissenting opinions. That could be done, but you could also have some sort of oversight committee of the AV that would, I think, control for these unfortunate situations that have happened. But at the end of the day, I'm sure there will be a way to find, to solve the problem and pull this thing and get it to work again. So I think there is a solution, but the solution requires understanding that there is a problem. Thank you.
Thank you, Jorge. Now I turn to Stephen.
Well, thank you very much. As I said at the outset of my presentation, I think it's really important to go back to first principles, what it is that we were trying to do in 1995, and the importance that we as members attached to certainty and as to what the rules meant. That was seen as being very important. And as Claudia pointed out, this isn't just about the appellate body. This is about the dispute settlement and its relationship to what it is that we agreed to. Now, we may not in individual cases believe that we got the right result, but the importance is that there is an importance to be attached to that certainty of access. With respect to the fact that we don't always agree with the decisions, I mean, it's really interesting. Thomas Graham said in November 2016, whether the appellate body has rightly reflected the intention of the negotiating parties when exercising its mandate to interpret WTO rules, or whether it's overreached by adding or diminishing to rights and obligations, is often in the eye of the beholder. And we tend to, or we run the risk of looking at individual cases and then extrapolating and saying, this is the system. No, the system is something that's somewhat different. We can't just be thinking about very narrow cases. We have to think about the overarching impact on the system and what it is that we wanted. Certainty is important. The fact that global trade is still growing and the global trade still exists, or disputes are still being launched at the DSB, is not a sign that the system is in good shape. And it doesn't measure, it's a snapshot of what's happening right now. It doesn't measure the long-term impact. And again, I think Claudia is right. An effective DS system is incredibly important for the negotiating function. We thought that was an important trait in 1995, certainty of the dispute settlement system, certainty to have the negotiating texts as decided, adjudicated. How are we to move forward? I think the impact can't be measured in 2019 or 2020. They will be long-term. We have to go back to what it is that we did in 1995 and why we did it and remind ourselves. It doesn't mean that the AB or the dispute settlement system is perfect. It doesn't mean that we shouldn't be talking about changes, but we need to remind ourselves what it is that we were trying to do. Those were really important factors for us in 1995, and for many of us, I think perhaps for all of us. I've heard it from the United States as well. Let's go back to 1995. Well, let's go back to 1995 and talk about what it is that was important.
Thank you very much, Stephen. Claudia?
Thank you, Ambassador. Ultimately, I think that there is an agreement that the crisis is very problematic. It is problematic, and I would like to stress it is problematic because everything that is being done by WTO members is not for the WTO members. It is for private undertakings. And private undertakings invest a lot of money and need certainty of the rules. For that reason, a functioning dispute settlement is essential to the relevance of the WTO. In that sense, I would just like to touch on something that Ambassador Shia mentioned, and it is the preoccupation of the U.S. as to how do you get an appellate body to accept and to go by the rules. And to the extent that there have been instances in which this has failed, it is important to find a way to solve that problem. And in order to solve that problem, you will need the participation of three elements. Number one, litigators. Litigators cannot continue to increase the number of claims while the appellate body is forced to comply to 90 days. There is a mismatch there. Second, the appellate body will have to be forced to focus on the issues that are relevant in order to be effective and in order not to go over its mandate. Thirdly, it will need the appellate body members to have certain practical expertise that have been missing in the past and that may explain some of the mistakes that may have occurred in the institution. The quality of the reports is not questionable for most of the cases, but it will also be important to remember that the central piece of dispute settlement is not the appellate body. The appellate body was there for correcting manifest errors, and experience shows that that doesn't occur frequently, that it's only seldom that has happened. The central part of the settlement is the panel mechanism, and that is a reality that I think everyone subscribes to, and therefore it's important simply to address that little element that in some aspects did not function as it was supposed to. Thank you, Ambassador.
Thank you very much, Claudia. And finally, Dennis.
Thank you, Dacio. There's been so much said and so much to react to, so I'll just take a few pieces. First, Jorge said the solution requires understanding there is a problem. And when I began this effort at the WTO, when I came to Geneva to talk about the appellate body, I don't think there was a widespread agreement that there was a problem. So I think now there is a general sense that the appellate body has not functioned the way it's supposed to be. So I guess perhaps that's progress. Secondly, I was struck by Claudia's comment that a non-functioning appellate body would adversely affect the rulemaking function at the WTO. And it's our view that the appellate body has adversely affected the rulemaking function at the WTO as members have sought to achieve through litigation what they cannot achieve through negotiations. Stephen talked about certainty, and for us, certainty means getting appeals within 90 days, no fact-finding, no advisory opinions, no adding rights and obligations. That's certainty. Unfortunately, I think others viewed certainty as a code word for jurisprudence. And I still view that as sort of a fundamental divide at the WTO. There are some members who view the appellate body as a court creating jurisprudence, a common law of trade. The fact is, in 1996, the appellate body said its rulings were not binding precedent. But in 2008, the appellate body reversed itself and said its rulings were binding precedent absent cogent reasons. And one of the rationales it gave for that is that it viewed itself as having a higher hierarchical value in the dispute settlement system. Its opinions have a higher value than panel opinions. We reject that. We feel that a panel report adopted by the DSB has the same value and is just as valid as an appellate as a report adopted by the appellate body. So until we come to a shared understanding of what the appropriate role of an appellate reviewer is, I think that's going to be a major obstacle going forward. And I think Stephen also mentioned Tom Graham's speech. Tom Graham is a former appellate body member, and he gave a speech recently, a farewell speech at Georgetown University, and he outlined a number of elements that he thought are characteristics that amounted to the appellate body acting like a court that was not accountable to the membership. I won't go through the list, but I would encourage people who are viewing to read Mr. Graham's speech, which appears somewhere on the WTO website. You can find it there. So, but thank you very much.
Thank you very much, Dennis. Now we will have just time for one round of questions because we just have one time for small period of time, I'm going to be reading many of these questions, and each one of you can pick the question that you would like to answer. First one, from Emma Farge from Reuters. I will be curious what the US and Chinese ambassadors see as the option following the Appellate Body September 15 ruling on US tariff and China, given the fact that the appeal will go into a void. Second question, of the issue raised with the AV, is the role of the Secretariat one of them? What can be done with this problem? Third question, Ambassador Shea asked for comments on USTR Lighthizer proposal. Can you please comment? Fourth question, can WTO member continue to negotiate new rules if there is not enforcement mechanism? Fifth question, how can members raise an appeal, what is called appeal in the void, if there is not operational appellate body? 6, do you think that the arbitration mechanism that Canada and the United States agree upon in the lumber dispute could be used broadly by the WTO members? 7, it is possibly technically to address the issue raised by the United States about the past AB mistakes. How do you think the WTO should deal with disputes report already implemented? 8, the ambassador of China raised doubt about the DS system with no appeal. Most international DS systems have only one level. Why does the WTO necessarily need an appellate review? I asked the speakers to respond the questions of their choice, and I suggest to follow the following order. I will start with Joao, then I will go to Angel, Jorge, Steven, Claudia, Shanshan, and Dennis. So I will give the floor to Joao.
Thank you, Lacio. Well, there are many questions, many different issues. Of course, that's not the intention to try to address. I think it's crucial to have a two-stage dispute settlement with appeals. You may have in other international arbitration systems only one level. We are dealing here with matters of legislation, some of them very intrusive into the members' legal systems, and the rulings are binding. We moved away from the pre-WTO times of GATT, where members could block in the DSP the adoption of the panel reports, and to make this acceptable, that the rulings are binding, it was agreed that we would have a second level where we could review errors of law, so that it gives the confidence to the members to go back to their parliaments and change the legislation whenever that's necessary. I can agree that the intention was not to create a system where members can drag on forever, and I think no one has acted with that intention. It is true that as we went along, the disputes have become very complex, some of them extremely complex, which have led to delays. We can discuss what was the reason of the delays, but I think that there has been delays. No one one can deny that, but it was not something that was intentional. It impinged on the rapid resolution of disputes, but we members also need to think our approach. I think that in many cases, members try to litigate until the end, bringing whatever arguments they could have, so that to win a case. So I think members as well, we need to think their attitude to dispute settlement in the WTO and to the appeals level. So I think it's important. Of course, if we do a reform and we improve on certain aspects, the disputes that have been adjudicated and adopted, they are adopted and they are implemented. No one is going to go back and restart again. And we are not, in our discussion, we are not discussing the substantive rules of the WTO agreements. We are discussing how dispute settlement operates. They operate in a more efficient way, but we are not discussing that we can litigate again because there was some reforms in the dispute settlement system. I think that's not at all and will not be the case. I would stop here. Thank you, Dacio.
Thank you very much, Joel. Sadly, we have the time that is our constraint, so we just have 10 minutes to finish this session. So I will give the floor to Angel. Angel?
I want to take question number 4, the relationship between enforcement and negotiations. Of course, it's very important that the enforcement happens, otherwise it will weaken the appetite to negotiate. Negotiate in order to get to some rights and to commit some obligation. I expect that to happen. I mean, this is, even though it's a cooperation organization, is an organization of hard rules. So this is not a WMO, World Montessori Organization. This is a World Trade Organization. So I insist, the problem of not having enforcement is that it's going to weaken the interests of members to participate in negotiations. Thank you very much.
Thank you very much, Angel. We'll move to Stephen now.
So a couple of things that I wanted to say. The one is, and I didn't say this in my second round, now I'm in my rebuttal, I guess. I just want to be very clear that Canada does not see the AB as an international court, nor do we see appellate body members as judges. But to the last question about how we deal with appellate body reform and decisions that have already been made, the only way we can possibly work is to be forward-looking. We can only talk about the appellate body or the dispute settlement system writ large going forward. And I do find it interesting that we're only talking about the appellate body. I think it's quite appropriate if some of the criticisms of the appellate body could be leveled across the system, particularly around timeliness. So it would be useful to talk about the entire dispute settlement system. I take Dennis's point on what the impact of the appellate body impasse might have on negotiations, but I think there's both, even if you don't buy my argument and the argument that Claudia made that this will have a negative impact on the actual negotiations, I think there's also an optical issue here that creates problems within the membership. And finally, with respect to USTR's Wall Street Journal article, it's interesting and it's positive in that we now have a much better sense of where the Americans might be coming from, and we've been wrestling with this. We spent a lot of time on the why, and we actually wanted to get to the what. What is it that needs to be done to address some of these issues? I have to admit, though, that we have some difficulty squaring the notion that we need to go back to 1995 with what USTR Lighthizer said in the Wall Street Journal editorial. So it's going to take a little bit to try to square those two ideas. Thank you.
Thank you, Stephen. Shen, you have 1 minute.
Thank you, Dacio. First of all, on the 8th question, why we need a two-tier system. First of all, from historical perspective, the establishment of Appellate Body was a response to the flawed GATT dispute settlement system, which plagued the members for many years. If the old system doesn't work, why should we return to it? And secondly, the survey recently sponsored by Beta Sman demonstrate that 90% WTO members believe that the two-tier system is needed. On the first question with regard to the dispute case between China and the US, we assume that the panel made an objective and a fair decision that the US Section 301 tariff are inconsistent with the MFN principle, and also recommend the US to bring its measures into compliance. We hope that will facilitate the prompt resolution of the dispute between China and the US. Thank you.
Thank you very much, Shanshan. Now I give the floor to Dennis.
I'm just going to answer number 4. Why negotiate new rules if not there's no enforcement mechanism? I mean, the U.S. is heavily involved in the negotiation over fishery subsidies, to discipline fishery subsidies. We need to get something done by the end of the year. So we're negotiating right now. U.S. is also heavily involved in the digital plurilateral. I don't think there are other issues in those negotiations that are much more of a potential problem than I think the appellate body situation. So I think it is possible to negotiate new rules, certainly under the current situation, and we certainly hope we can do so. So thank you.
Thank you, Dennis. Claudia, 1 minute.
So 30 seconds to question 4, 30 seconds to question 2. On rulemaking, the preoccupation that I would see as a distant observer is that to the extent that the rules appear to be not enforceable, there may be in the long run less interest in negotiating rules. And hopefully that doesn't happen because, as mentioned by the US ambassador, the fisheries negotiation on subsidies and fisheries is extremely important and overdue, and therefore, hopefully, there is success soon. And 30 seconds on Secretariat, what can be done? One of the elements that could be brought in is mobility for the director. There was a director that was over 10 years, and of course, if you are there over 10 years, while the members of the appellate body are part-time and are there for 4 or 8 years, there is a relationship that is not balanced, and therefore that would have been an easy element to incorporate. Another element to incorporate could be that the reviews, when the appellate body starts to surpass its mandate, 90 days, it happens once, it happens twice, there has to be a control mechanism from the members. And eventually, you can come up with the idea of an award that is not rendered in the time foreseen is null and void, because it was not rendered in the time foreseen. So there are mechanisms where you can force the appellate body to fulfill its role, remembering that the central element of dispute settlement is the panel phase. Thank you.
Thank you very much, Claudia. Now I give the floor to Jorge. You just have 1 minute, less than 1 minute, Jorge, because I have to say goodbye.
Oh, so sorry. Well, with respect to the role of the Secretariat, I think in part it was their mistake because, as we all know, some of the reports actually read like PhD thesis, going into exceedingly complexity. But frankly, there was a void because the fact of the matter is that we cannot pretend that there'll be a dispute settlement system where you cannot possibly look back and then, take the ratio decidendi and apply it. So even if you don't call it case law, as a practical matter, there always is going to be the possibility to look back. And I think, we have to recognize that and say, okay, we want that, but better managed. And very briefly.
Thank you, Jorge.
Okay.
Thank you very much. Unfortunately, we have to end this session. We are going to be disconnected soon, but I believe that miracles are possible and nothing is impossible. So together we can find solutions to the WTO dispute settlement problem. Thank you to all, and thank you to all of those who has been seeing us virtually. Bye-bye.